22-9 FY, People versus Deandre Booker.
Your Honor, Randall Kane appearing as arraignment attorney on behalf of Deandre Booker. Mr. Booker, state your name for the court, please.
Deandre Booker.
And thank you. Good morning, Your Honor. Steve Fox on behalf of the people.
All right, and Detective Les Bronx, can you please go to the table next to Mr. Kane? Mr. Booker, did you talk to Mr. Kane today?
Yes.
Did he go over your rights with you?
Yes.
Did you understand all of those rights?
Yes.
Do you have any questions regarding your rights?
No.
I'm going to enter a not guilty plea for purposes of arraignment. With regard to bond, we'll start with Mr. Kane.
Your Honor, Mr. Booker is 32 years old. He's in custody on this charge. He states he is not employed. He lives at the same address. He also states he's not on probation or parole. I'd recommend a reasonable bond in this matter.
All right, and Mr. Fox.
Thank you. Good morning, Your Honor. Obviously, we're here on a 4-year felony for lying to a peace officer on a violent crime investigation. This is, of course, as Your Honor is aware, involving Ms. Elkins. And the court is to consider MCR 6.106F and MCL 765.6, a number of factors. I'm going to hit on a few if you don't mind. The first is the protection of the public. The underlying matter, although not the charge specifically, but the underlying matter obviously involves a crime of violence, potentially. We are still seeking Ms. Elkins. The defendant, we suspect and believe, may know where she is, and a concern is her safety if, God forbid, the worst has not happened yet. So with respect to that, Judge, I believe that there is a risk to the public, specifically if she were still alive, and that's what we're all hoping for, of course. The other is the defendant's risk of non-appearance and the likelihood of conviction. Likelihood of conviction, Judge, the defendant made several material factual misstatements to Detective Lasprins and recited those to the court during the course of the initial swear-to. The defendant was aware that we were investigating a missing persons report. He was aware that there was some belief of his involvement. He made misstatements about both his location as well as Ms. Elkins and how she may have left his vehicle, left his apartment complex, all of which we can demonstrate by objective evidence and video evidence to be false. So there's a high likelihood of conviction on these cases, on these matters. And then last and most importantly for the court's consideration, I think at this point, is the probability or improbability of returning for trial. We have a history that includes charges at least. We do not have the disposition, but we did recover DD-214 from his time in the U.S. Army. It looks like in 2016 he was charged with a couple of matters, including larceny of private property and, more importantly, fraudulent ID documents. And then in 2017 he was charged with desertion, or the absence without leave, going AWOL from the Army. Ultimately, he was discharged less than honorably, although it was not a dishonorable discharge. He was discharged from the Army in a less than honorable means or manner. We know that after the conversations, before the conversations with Detective Lasprins, but we believe after the underlying events of this case, he fled from Macomb County, went to Flint, where he was apprehended and brought back to Roseville. And we know that during that time, while he was in Flint, he accessed the internet to search for such things as fastest routes from Flint to Ohio, what to do on the run, is blood traceable, how to beat a polygraph, and deleting Google history. So Judge, I think by his own words and search history, by his prior conduct, and by what is frankly at stake in this particular matter, he's of significant risk of flight. With that, I would request a significant bond. I'm asking for a $500,000 cash surety bond, no 10%, and that a steel cuff GPS tether be attached should he make that bond.
All right, Mr. Kane, anything further from you?
Nothing further, Your Honor.
Detective Les Bronx, is there anything you wish to add?
No, ma'am, not this time.
As Mr. Fox indicated, there are many things the court has to look to with regard to setting bond and determining bond. This court looks most closely at the risk of harm to the public and the likelihood of the defendant's appearance in court. I will note for the record that this matter is currently charged as a 4-year felony. I will also note for the matter that while Mr. Fox did point out several instances from the defendant's time in the military with regard to any sort of matters that came up with regard to larceny or desertion, that there is no other criminal history presented. But that being said, the matter being investigated does involve a missing person, which is a very serious matter. And the court takes very seriously that the allegations being made are that the defendant is lying to a police officer regarding material facts about a missing person at this time. That gives the court great concern about the risk of harm to the public and the likelihood that the defendant will make sure that he appears in court for both this matter and any potential further charges that may be brought by the prosecution. At this time, the court is going to assess an amount of bond in the amount of $250,000 cash surety, steel cuff tether prior to any release. The PCC date in this matter will be January 22nd, 2025 at 8:30 a.m. on Zoom in front of Judge Bodecker. The exam date will be January 29th, 2025 at 8:30 a.m. in person in front of Judge Bodecker. I have referred the matter to the Office of the Public Defender for appointment of counsel at this time. If the defendant does retain counsel, that counsel can send in a substitution of attorney. Is there anything?
Thank you, Judge. And just,
Party?
I apologize, Judge. Just one clear, you indicate steel cup tether, that is with G, that's correct?
Yes.
Thank you. Nothing further from the people, Judge.
Anything
Nothing
further,
further.
Mr. Green? Okay, you guys are all set today. Have a good day.